I have a fairly good understanding of the issues before me today. I don't need to hear anyone on the jurisdiction of the court. I know it was raised by has been raised by the parties. I'm satisfied that the court has jurisdiction to entertain this, and I don't think, unless somebody wants to wax eloquent on standard of review, I don't think I need to hear you on standard of review. I think from my reading of the memorandum, everyone agrees that issues of procedural fairness are on the standard of correctness, and everything else is on the standard of reasonableness. My understanding is that, and these are my words, not your words, that there are basically three issues before me that require determination, roughly in this order. The first is whether or not a decision taken by the responding parties that there was some mistake, error, omission, ambiguity in the 2008 agreement that required to be cured was a decision that was taken in a reasonable manner. Was that a reasonable decision? The second issue, as I see it, is whether the terms of the supplemental agreement were reasonable. And the third, as I see it from the parties' memorandum, is whether the applicants were denied procedural fairness. That's my take on the material. If council has a different view or a different expression, I would ask you to let me know. That's how I see it. We have set aside a day for these applications, which, other than some facts that are unique to the individual applicants, basically rest on the same evidence. I don't know if council had an opportunity to discuss how this day is going to be split up. I see someone shaking their head that they have had. That's good. Perhaps somebody could inform me what that understanding is.
Yes, we've spoken with the council and we've agreed to split the time beginning, whatever time is available to the court. So I'm not sure how late you intend to sit, but we've agreed to split the time approximately.
I normally sit till 4:30. I don't cut people off mid-sentence at 4:30, but at 4:35 I might. So, take that for what it's worth. And I normally take a morning break and an afternoon break of about 15 minutes, and then lunch of about an hour and a quarter. I've tried an hour, and it just doesn't seem to be enough time for people to get back. And in terms of the responding parties, who's going to take the lead here?
I will, Justice, I will go first, followed by my friends.
Okay, great. And we were not advised that we might have a full house, so to speak, so I understand there may be some people who haven't been, there are not enough seats for everyone, and had we been informed, we would have taken some steps, but it is what it is, so we'll deal with it. But it's a delight, frankly, to see people in the courtroom. So, with all of that, counsel, do you want to start?
Thank you, Justice Zinn, and good morning. As His Honor knows, I'm Jamie Lickers. I'm counsel to the applicants in these matters. I'd like to begin by providing a brief overview of the case, followed by a summary of the issues at hand, a summary of the relief requested by the applicants, and then a more thorough examination of the facts leading into our legal arguments. The decisions before the court today stem from the negotiation of an agreement granting the long overdue recognition of the Mi'kmaq people of Newfoundland. The agreement created a new band Mi'kmaq people in Newfoundland and sought to restore Indian status to the descendants of the Mi'kmaq people who should have been recognized when Newfoundland joined Confederation in 1949. The eligibility criteria for the enrollment in the Halapu Band included a requirement that individuals self-identify as Mi'kmaq. And while this is not generally a criteria for registration as a status Indian in Canada, it is not the criteria itself that is at issue today. What is at issue today is the manner in which the criterion was subsequently narrowed by the respondents to limit the eligibility of otherwise worthy applicants, which resulted in the denial to tens of thousands of Mi'kmaq people membership in the band and registration as Indian status, thereby disentitling them to access to programs and services, membership in their communities, and constitutionally protected rights. There are 3 decisions before the court today. The first, as Your Honor rightly noted, is the decision of Canada and the Federation of Newfoundland Indians to enter into the supplemental agreement to amend the self-identification criteria for enrollment in the Halapu Mi'kmaq Band. The second and third decisions at issue, of course, are the 2 resulting decisions for the named applicants in these cases, Sandra Wells and Dave Wells, who were denied membership in the Halapu Mi'kmaq First Nation and denied registration as status Indians. It's not all that helpful, Your Honor, that the applicants have the same last name, although they are unrelated to one another. Accordingly, I will refer to the applicants by their first names throughout my submissions. I would like to summarize the relief that the applicants are seeking from the court today. First, the applicants are seeking a declaration that the decisions of Canada and the FNI to enter into the supplemental agreement to amend the self-identification criteria and to remove the applicant's appeal rights was unreasonable. The applicants submit that these decisions were unreasonable on the following grounds. First, the amendments were not permitted by section 2.15 A or B of the original agreement. Second, the amendments were made on the basis of irrelevant grounds or for improper purposes. Third, the amendments arbitrarily invalidated applications made after the date of the recognition order. Fourth, the amended self-identification criteria are under-inclusive. Fifth, the amendments fettered the discretion of the enrollment committee. And sixth, the decision to amend the self-identification criteria failed to proportionately balance the applicant's charter protections with the agreement's objectives. The applicants are also seeking a declaration that the enrollment committee breached the applicant's rights to procedural fairness in failing to provide adequate notice of the assessment criteria that would be imposed on them. The applicants request an order quashing the decisions to deny their membership in the band on the basis that they failed to meet the self-identification criteria. The applicants also request an order including their names on the founding members list for the band. And as an alternative, the applicants request an order remitting the decisions to deny their applications back to the enrollment committee to be evaluated in accordance with the original agreement or on such terms as this honorable court deems just. Your Honor, the facts in this case are extensive and complex. And while I will not purport to take you through the entirety of the facts as would be found in the multiple volumes of materials before you, I wish to highlight the facts that are particularly relevant to the issues at hand. The decisions at issue arise from both the negotiation and implementation of an agreement negotiated between the respondents in these cases to confer membership and Indian status on eligible individuals. The agreement was intended to recognize the Mi'kmaq people of Newfoundland, whose identity and recognition had been denied since 1949 when Newfoundland joined Confederation. The agreement at issue followed decades of stalled negotiations and the launching of an action in federal court. In 2006, an agreement in principle was reached between the Federation of Newfoundland Indians and the Government of Canada. That agreement in principle was reached following extensive consultation with the membership of the Federation of Newfoundland Indians. This consultation with the FNI membership was crucial for a number of reasons. First, because the membership of the FNI would be required to ratify the agreement as a condition of its validity. And second, the creation of the band was dependent on the attainment of a threshold of 50% of the membership of the FNI as approved members. After the AIP was initialed in 2006, the FNI froze its membership for two purposes. First, to finalize that voters list to determine the threshold required to pass the AIP, as well as to determine what that threshold number was for membership in the band and for the creation of the band. During this time, it was recognized that the membership of the FNI may not be entirely reflective of the total Mi'kmaq population in Newfoundland and more broadly. And during this time, the parties commissioned a membership survey. That membership survey can be found at volume 4 of the applicant's record, tab 13B. Your Honor, you will see on page 1, following the table of contents, under the background to this membership survey, it states that the Federation of Newfoundland is currently negotiating with the Government of Canada for the recognition of its members under the Indian Act.
Just a minute.
Of course.
Is this page 893?
895. Yes, it starts on 893, sir.
895. Thank you.
So Your Honor will see in the first paragraph under the background heading, it summarizes that the Federation of Newfoundland Indians is negotiating with the Government of Canada for recognition of its members under the Indian Act. In order to determine the financial implications of recognition and the impact on the Government of Canada, the FNI and its affiliated bands need to determine how many individuals could come to be recognized. The second paragraph of the background information notes that the affiliated bands maintain their own membership lists. But you will see beginning in the second sentence on the second paragraph, the authors of the report indicate there are individuals eligible for membership in each of the 9 bands of the FNI that are not currently registered. There is an expectation that many of those eligible for membership but not yet registered may register once they become aware that they are eligible for recognition under the Indian Act. If we turn over, not to the following page, Your Honor, but page 897 of the record, under limitations, you'll see that the authors of the survey note, it is important to realize that it's virtually impossible to develop an estimate of potential membership that is truly precise. They then proceed to list a number of limitations to this membership survey. Number one, the sample frame consisted of current members only. The authors note that there are likely individuals in the general population who have Aboriginal ancestry, but no relatives registered with any of the 9 affiliated bands. These individuals have no chance of being included in this survey. Similarly, under limitation number 3, they explicitly note that the sample frame excluded members outside of Newfoundland and Labrador. Estimates would, as a result, exclude entire families that have moved out of the province. They may either move back to Newfoundland and Labrador or request services from outside of the province. Following the signing of the agreement in principle, and prior to the ratification of that agreement in principle, the Federation of Newfoundland Indians membership increased to approximately 10,500. As noted by Mr. Brendan Shepherd, the former president of the Federation of Newfoundland and the former chief of the Hallelujah Band, this increase largely followed the Prime Minister's visit to St. George's and the announcement of the formation of the First Nation. Assurances were repeatedly provided to the membership of the FNI that they would have the opportunity to vote on any agreement reached with Canada regarding the formation of the band. This commitment is reflected in the agreement in principle, which provided that ratification by the FNI membership was a condition precedent to its validity. As a result, extensive consultation occurred with membership of the FNI leading up to the ratification vote, which was held on March 29, 2008. The result was that 90% of the FNI membership who voted in the ratification voted to accept the agreement in principle. In the spring of 2008, following the successful ratification, the FNI publicly announced the AIP had been ratified and indicated that the band could be established as early as 2010. I'd like to direct Your Honor to, again, Applicant's Record Volume 4. Tab 13F, sir. This, Your Honor, is a newsletter, as you'll see at the top, from the Federation of Newfoundland Indians. It's dated spring 2008. It's a message from the President. Oh, if you go over onto the second page of the announcement, the second full paragraph on this page starts, "It also means that the Newfoundland Mi'kmaq who meet the enrollment criteria will gain access to federal programs that are dedicated to status Indians, such as post-secondary education and non-insured health benefit programs." Right beside that paragraph, Your Honor, in the second column of the article, halfway through the second paragraph, it says, "Once the first phase of this registration is complete, the Mi'kmaq of Newfoundland will be added to the Federal Indian Registry and the band, named Halapu First Nation Band, will be established. It is anticipated that the band could be established as early as 2010. It was on June 23rd, 2008, that the FNI and the federal government executed the agreement in principle. Once it was executed, the AIP became the Agreement for the Recognition of the Halibut Mi'kmaq First Nation, which I will refer to as the original agreement throughout my submissions. As the evidence demonstrates, and as acknowledged by the respondents, the negotiation, ratification, and execution of the original agreement were extensively publicized. This was a historic event for the province of Newfoundland and for the Mi'kmaq people. News of the creation of the band was widely publicized and celebrated. I'd like to take your honor again in volume 4 at tab 13D of the record. Oh, my apologies, that's the document that we were just at. Tab 13E, Your Honor.
Yes.
This is a December 1st, 2007 article from the Telegram. The first page is just a picture. The second page has the substance of the article. Harper and FNI reach agreement on status. You'll see the second full paragraph of the article, which begins, "The members of the Federation will have Aboriginal status under the Indian Act once the 9 bands of the group ratify the agreement." Of course they meant Indian status, there's no such thing as Aboriginal status. We turn to volume 2 of the applicant's record. At tab 11K, we have an article from the Western Star dated August 14th, 2008, announcing the celebration of the ratification. The first paragraph states, "The agreement in principle to form the Halibut Mi'kmaq First Nation Band was ratified by the federal government in June, and now the next step of formulating a list of registered members will soon begin." If you turn over to the second page, Your Honor. The fourth paragraph down, which begins the programs and services, states, "The programs and services that will become available to the members of the Halibut Mi'kmaq First Nation Band after it is formed include post-secondary student support, band support funding, band employee benefits, Indian registry administration, community economic development opportunities, and non-insured health benefits through Health Canada." We go down 2 further paragraphs, Your Honor. There's a paragraph that begins, "The deal is open to any Mi'kmaq people in the province, even if they are not FNI members." These are just a few examples from the many publications during this time period publicizing the formation of the band and the benefits which would flow to its members. Your Honor, I'd like to take you through some of the key provisions in the original agreement, which can be found in volume 2 of the applicant's record.
Yes.
At tab 11F. Page 378 of the record, Your Honor. That page includes Chapter 4, specifically 4.1, the eligibility criteria for enrollment. An individual is eligible to be enrolled as a founding member if that individual is alive at the time of the recognition order and in the assessment of the enrollment committee. The item that's relevant today, of course, is subsection D. On the date of the recognition order, and then subsection 1, self-identifies as a member of the Mi'kmaq group of Indians of Newfoundland. Now, it's important to note, sir, that the date of the recognition order was not known to the parties or the applicants at the time that this agreement was drafted. The recognition order is the order in council creating the band, which could not have been done until a later time when the application threshold had been met, which is why the term recognition order is used as opposed to an actual date. This agreement and this eligibility criteria is the only agreement that was in force and available to applicants when they applied up to the date of November 30th, 2012. It's also important to note that the agreement specifically contemplated that many applications would be evaluated after the issuance of the recognition order.
Am I right that that date is September 23?
It became September 22nd, 2011. That's correct. It was actually meant to be much earlier, Your Honor. The order creating the band, which is the recognition order, was meant to be issued after the conclusion of the first stage of the enrollment process. That first stage of the enrollment process was meant to last 12 months with the possibility of a 6-month extension if the threshold for numbers had not been met. In the end, the threshold for membership was met during the first phase of the enrollment process. And so the first phase concluded on November 30th, 2009. The recognition order was not issued immediately following.
But is any of that relevant for my purposes? I mean, I'm stuck with the language as a U of the agreement which says it's the date of the recognition order. I just wanted to confirm. My reading was that was September 22nd, 2011.
That's right. And it was issued following litigation, which is not
I
relevant
don't
to
need to
this.
know any of that. I don't think. Although I do know, but I don't need to know.
Fair enough, Your Honor. So the application period under the original agreement was intended to last for 48 months. Stage 1 for 12 months, where a threshold had to be met, and then stage 2 for a period of 36 months, for a total period of 48 months or 4 years. No application was to be submitted after the conclusion of the second stage of the process, the date for which came to be November 30th, 2012. So that was the deadline for submitting an application for enrollment in the band. I'd like to take a look at section 4.2.1 of the agreement, which is the establishment of the enrollment committee. 4.2 sub 1, an enrollment committee shall be established by the parties to make the assessment referred to in section 4.1 in accordance with the procedures set out in section 4.4 and with the enrollment committee guidelines appended as Annex A to this agreement. If we turn to the guidelines, Your Honor, section 24 specifically, which is on page 400 of the record.
Yes.
24, of course, is the other provision that is at issue today, which states that a signed application form constitutes sufficient evidence that the applicant self-identified as a member of the Mi'kmaq group of Indians of Newfoundland. If we turn to sections 31 and 32 of the Enrollment Committee Guidelines on page 402 of the record, these provisions set out the standards of evidence for the Enrollment Committee in assessing applications. Section 31 says, except in circumstances where the agreement or the guidelines provide more specific directions, individual components of evidence shall be assessed for relevance and reliability, and shall be given such weight as the enrollment committee considers reasonable and appropriate in all the circumstances. Section 32 goes on to state that the enrollment committee must be satisfied that the evidence, considered in its entirety, is sufficient to establish, on a balance of probabilities, that the applicant complies with each component of the eligibility criteria set forth in subsection 4.1 of the agreement. I'd like to turn to section 4.3 of the agreement. On page 383 of the record. Section 4.3.3 is the appeal right also at issue today, which states that within 30 days of the mailing of its decision by the enrollment committee, the applicant and the parties shall have the right to appeal the decision of the enrollment committee by sending an appeal notice to the appeal master with a copy to the enrollment committee. There was no limitation in the original agreement on the right of individuals to appeal. Finally, Your Honor, I'd like to take a look at section 2.15, which is at issue in these applications. Those are the amendment provisions of the original agreement. Those can be found at page 373 of the record. As reflected by this provision, Your Honor, the general rule was that this agreement could only be varied, changed, amended, added to, or replaced by written agreement between the parties, ratified through the same procedure as this agreement was ratified, save and except that the parties may agree in writing from time to time to amend the agreement without further ratification or approval for certain purposes. And those purposes, as we know today, Sub A allowed the removal of conflicts or inconsistencies with applicable law. B deals with the issue of correcting inconsistent provisions in the agreement. And C, which is not at issue, was simply to extend timelines under the agreement. The enrollment process under the original agreement commenced on November 30th, 2008, and the first stage of that process ended on November 30th, 2009. During that time, 25,912 applications for membership were received. Of those 25,912 applications received in the first year, 23,877 were approved. Rounded to the nearest whole number, that's a 92% approval rate. By the fall of 2009, as Mr. Shepard confirmed in his cross-examination, approximately 7,400 letters of approval had already been sent to successful applicants. The second stage of the enrollment process began on December 1st, 2009, and continued until November 30th, 2012, which was the deadline for applying for membership in the band. During this second stage of enrollment, approximately 75,000 applications were received. The Halapu Mi'kmaq First Nation Band was created by an order in council on September 22nd, 2011, which, as you know, is the date for the recognition order. Of course, what this means, Your Honor, is that between stage 1 and stage 2 of the application process, over 101,000 applications for band membership were received. In early November 2012, Canada publicly expressed concerns that the number of applications raised questions about both the credibility of the application process and the integrity of the band. Your Honor, I'd like to go to volume 3 of our application record. Tab 12L. This is a transcript, Your Honor, of an interview with Greg Rickford, who was the Parliamentary Secretary for the Department of Aboriginal Affairs and Northern Development at the time. On the second page, page 831 of the record, towards the bottom, Mr. Rickford is speaking. Says, you know, this is an agreement that I think reflects the desire by the federal government to work together with members of the Halakoo Mi'kmaq First Nation, the Federation of Newfoundland Indians, and to establish a process that focuses on the membership process. And our goals, of course, are to continue to work together, ensure credibility in that process, and of course protect the integrity of the First Nation community, the Federation of Newfoundland Indians, and the members of the community themselves. Canada and the FNI entered into negotiations in the fall of 2012. At no time during those negotiations did consultations with the applicants in this case occur, with other individuals who had applied for membership in the band, or those individuals who were already members of the newly formed Halakoo Mi'kmaq First Nation. The supplemental agreement was signed by Canada and the FNI on June 30th, 2013, and it was not ratified pursuant to the provisions of the original agreement. It is important, Your Honor, to keep in mind that the application deadline of November 30th, 2012 had already passed when the supplemental agreement was executed. The supplemental agreement was announced in a joint press release on July 4th, 2013, in which both parties alleged that the high number of applications were not credible and undermined the integrity of the First Nation. And I'd like to take you to volume 3 of our application record. At tab 12F. This is the news release, Your Honor. In the second full paragraph, it states, the Mi'kmaq people of Newfoundland hold a unique place in Canadian history, and our government is committed to implementing the 2008 agreement for the recognition of the Halakoo Mi'kmaq Band in a manner that reflects the original intent of the agreement, said Minister Valcourt. I am pleased that we have reached a supplemental agreement that will address our shared concerns about the enrollment process. This agreement will protect the integrity and credibility of the Halakoo Mi'kmaq First Nation by ensuring that only those with a legitimate claim to membership are registered and enrolled. The fourth paragraph, Your Honor, the last sentence, it goes on to state, after reviewing the changes in the supplemental agreement, this ensures that all applicants, no matter when they applied in the process, will be treated fairly and equitably. I'd like to look at the supplemental agreement itself, which can be found in volume 2 of our record at tab M. I'd like to start with the preamble, Your Honor. first page of the supplemental agreement, there's a preamble outlining the eligibility criteria under section 4.1 of the original agreement. If we go over the page to the second full and whereas clause, the supplemental agreement states, whereas applying section 24 of the Enrollment Committee Guidelines, Annex A to the agreement, to applications signed after September 22nd, 2011, would result in the acceptance of evidence that would not be sufficient to meet the criterion that the applicant self-identified as a member of the Mi'kmaq Group of Indians of Newfoundland prior to and on the date of the recognition order, as required by 4.1 sub D sub 1 of the agreement. The second to last whereas clause in the preamble states, and whereas the volume of applications submitted by individuals seeking membership in the band far exceeded the reasonable expectation of the parties so as to overtake the capacity of the enrollment process. And the last whereas clause, and whereas the parties' original intention was and continues to be that all applicants be treated in a fair and equal manner. The supplemental agreement made a number of retroactive changes to the criteria in the original agreement. As you'll recall, Your Honor, section 4.1 sub D sub 1 of the agreement required that an applicant self-identify as Mi'kmaq on the date of the recognition order. Section 24 of the guidelines stated that a signed application form was proof of self-identification. If we turn to section 8 of the supplemental agreement, which begins on page 510 of the record, Section 8 of the supplemental is where we find the amendments to Section 24 of the original agreement. Beginning at the bottom of page 510 of the record, the parties state, therefore, Section 24 of the Enrollment Committee Guidelines is amended as follows, and we have 3 subsections. The first subsection introduces a requirement that in order to satisfy the self-identification criterion of the original agreement, an applicant is required to provide objective documentary evidence of self-identification that predates or is contemporaneous with the signing of the original agreement. We see that clause specifically, Your Honor, if we go over the page to page 511 of the record. Near the top, where the paragraph on that page begins, there must be on the applicant record in accordance with subsection 24.2 or 24.3, and there's the requirement there. Objective documentary evidence that predates or is contemporaneous with the signing of the agreement for the recognition of the Halapu Mi'kmaq Band. Now, it's important to note, it's not the date of the recognition order. This requires objective documentary evidence that predates or is contemporaneous with the signing of the agreement, and the agreement was in June of 2008. Now, subsection 2 of the section 8 of the supplemental agreement goes on. An application form signed on or before September 22nd, 2011, the date of the recognition order, constitutes sufficient evidence that the applicant self-identified as a member of the Mi'kmaq Group of Indians of Newfoundland leading up to and on the date of the recognition order. So subsection 1 says everybody has to produce objective documentary evidence from June 2008 or earlier. Subsection 2 says, but if you signed your application form on September 22nd, 2011 or before, you've met that criteria. Now, for those people who hadn't signed their application forms before September 22nd, 2011, they find themselves dealing with subsection 3. So, for them to satisfy the requirement in subsection 24.1, There is an exhaustive closed list of documents that must be provided. In summary, those include their name appearing on a listed Mi'kmaq organization found in subsection 1. Subsection 2, a 2006 or earlier census where the individual identified as either Aboriginal, North American Indian, or a member of an Indian band or First Nation. Subsection 3, a copy of a Newfoundland newspaper article, again predating the June 23rd, 2008 signing of the agreement, reporting the participation of the applicant as a member of the Mi'kmaq group of Indians in a ceremonial, traditional, or cultural activity. And to be clear, this is not proof that someone attended one of those activities. It's a newspaper article reporting that they had appeared at such an event. And then subsection 4, this is subject to the written approval of the parties. A certified true copy of an application form filled out by a resident on the island of Newfoundland, again prior to the June 23rd, 2008 signing of the agreement, either for a job in government or public institution, an Aboriginal organization, or for a program or benefit, again indicating that they self-identified as Mi'kmaq, Indian, or Aboriginal. And then over the page we have number 5. This category of documents is again subject to the written approval of the parties. A document submitted to or issued by a government, public institution, the Federation of Newfoundland Indians, or there's a number of other Mi'kmaq organizations listed. Again, prior to the June 23rd, 2008 signing of the agreement, showing that the applicant self-identified as a member of the Mi'kmaq group of Indians. Finally, Your Honor, I'd like to turn to sections 6.2 of the supplemental agreement. On page 509 of the record. Section 6 of the supplemental agreement is the provision that modified the appeal rights of the applicants. Specifically, sub 2 of that section says an applicant shall not have any right to appeal from the decision of the enrollment committee denying an application on the grounds that, and B is the one that is relevant for our purposes, the name of the applicant or the applicant's parents is not on one of the lists mentioned in 24 sub 2, and the applicant has not submitted any objective documentary evidence of self-identification. And that, of course, amended the provision in the original agreement, which provided a right of appeal to all applicants. During cross-examinations, Your Honor, representatives of both respondents acknowledged that they either did not or could not confirm that they had examined the availability of any of the documents that came to be listed in the new section 24. The general availability of people appearing in newspaper articles, the availability of applications for government jobs or public institutions. They could not confirm at the relevant time whether such documents would even include a right to self-identify. Additionally, it was acknowledged on the record during the cross-examination of Mr. Gray that the short form census does not include an opportunity for an individual to self-identify. It is only the long form census which includes that option. And Mr. Shepard testified during his cross-examination that only 1 in 4 houses in Newfoundland received the long form census. a result of the negotiation of the supplemental agreement, the parties mandated the enrollment committee to assess or reassess all applications for membership in the band that had not been previously rejected. This reassessment process began in the fall of 2013. And in November of 2013, those applicants who had not been previously rejected were sent a standard form letter from the enrollment committee regarding these amendments. A copy of that letter, Your Honor, can be found in volume 1 of our record. At tab 8D. This letter, Your Honor, does not advise the particular applicant to whom it is addressed whether his or her particular application is deficient or defective. It doesn't advise the applicant of the date of his or her application. Rather, it provides that applicants have an opportunity to submit additional information. This letter also indicates that as a result of the supplemental agreement, the deadline for completing the review of all membership applications was extended to January 31st, 2017. On that date, the enrollment committee sent letters of decision to 100,674 applicants. Of the 30,728 applicants who signed their application forms on or before the date of the recognition order, 100% met the self-identification criteria. And 15,790, or 51.3%, had their applications for membership approved. Of the 69,946 applicants who signed their application forms after the date of the recognition order, 2,254, or 3.2%, had their applications for membership approved. Of those 69,946 applicants, 57,820, 82.6%, had their applications rejected on the basis that they could not provide evidence of their self-identification. Your Honor, I'd like to speak to you about the particular applicants in these cases. Sandra Wells was born in St. Anthony, Newfoundland in 1966. She has an ancestral connection to the pre-Confederation Mi'kmaq community of Bay St. George through her great-great-great-great-grandfather, Gabriel Lejeune. She has lived a Mi'kmaq way of life since childhood and continues to pass on Mi'kmaq traditions to her children. She applied to be a member of the Halipuu Mi'kmaq First Nation on September 27, 2012, before the application deadline of November 30th, 2012, after the date of the recognition order of September 22nd, 2011. At the time Sandra submitted her application, a signed application form constituted proof of self-identification. Following the signing of the supplemental agreement, on or around November 10th, 2013, Sandra received the standard form letter from the enrollment committee indicating that that her application would be assessed in accordance with both the original agreement and the supplemental agreement. It advised her that she had the opportunity to submit additional documentation, and that any additional documentation had to be received or postmarked by January 31st, 2014. The letter itself did not expressly advise Sandra that her application was deficient and would be rejected without providing additional documentation. The enclosure accompanying the November 2013 letter indicated that pursuant to the supplemental agreement, applicants who submitted their applications after the date of the recognition order were required to provide one of 5 documents. And those are the documents, of course, we reviewed in section 24 sub 3. Sandra had not been a member of any voluntary Mi'kmaq organization, despite attending numerous cultural and traditional events at which she may have been photographed. To her knowledge, none of those photographs ever appeared in a newspaper. She requested a copy of her census from Statistics Canada, but never received it. And she could not provide any copies of job applications from before June 2008, where she self-identified as Mi'kmaq. In January of 2014, having determined that she could not provide any of the documents required by 24 sub 3, she submitted additional documentation, including a sworn declaration to which she attached additional information, including photographs of herself conducting Mi'kmaq cultural activities and leading a Mi'kmaq way of life. She attached a copy of a 2010 job application where she identified as Aboriginal. She included a self-authored letter attesting to her lifelong identification as a Mi'kmaq person and numerous photographs. Over a year later, on or around February 6, 2017, Sandra received a letter from the Enrollment Committee advising her that her membership application had been rejected on the grounds that she did not meet the requirements for self-identification in section 4.1 of the original agreement and section 24 of the guidelines, and that in accordance with the supplemental agreement, the Enrollment Committee's decision was final and not subject to appeal. The applicant, David Robert Wells, was born in Corner Brook, Newfoundland on April 5th, 1953, where he continues to reside. Dave is the current chair of the Mi'kmaq First Nations Assembly of Newfoundland, which is a not-for-profit corporation dedicated to the fair and equal treatment of all applicants to the Halaku Band. He is also a member of the Canadian Aboriginal Veterans Serving Association. Dave was a member of the Canadian Armed Forces and served this country for 35 years, having been stationed in various countries throughout his career. After returning to Newfoundland in 2003, he learned of the negotiations for the formation of the Halaku Band. Having always suspected his family's Mi'kmaq heritage, and after being informed by members of his family that they in fact had Mi'kmaq ancestry, Dave began to research his ancestry in late 2011. In April 2012, Dave located a census document from 1921 which identified his 5 maternal aunts and uncles as Mi'kmaq. His mother was not yet alive in 1921, so she was not listed alongside her siblings. Dave has an ancestral connection to the pre-Confederation Mi'kmaq community of White Bay, where his Aunt Mary and his mother resided. Dave submitted his application for membership in the Halaku First Nation on October 1st, 2012, again before the deadline for applications, but after the date of the recognition order. On or around November 10th of 2013, Dave received the same standard form letter that Sandra received. The letter did not advise him that his application was deficient or the date of his application. Having determined that he could not provide one of the 5 documents listed in the enclosure with his letter, Dave did not submit any additional information. On or around February 6, 2017, Dave received a letter from the enrollment committee advising him that his application had been rejected on the grounds that he did not meet the self-identification criteria in accordance with the supplemental agreement, and again, that the enrollment committee's decision was final and not subject to appeal. Unless Your Honor has any questions about the relevant facts, I'd like to move on to our arguments.
Sure.
Per your instruction, Your Honor, I will skip over our submissions on jurisdiction and standard of review and move right into our argument that the amendments were unreasonable. Your Honor, the applicants would ask you to keep three principles in mind while we examine the reasonableness of the amendments at issue. First, as Justice Manson recognized of this court in the Foster and House decisions, the original agreement we are dealing with today is not a commercial contract, and it should not be treated as such. The original agreement governs the conduct of the enrollment committee, whose decisions, and I quote from Justice Manson, have long-term consequences for an applicant's personal identity, inclusion in his community, the entitlement of his descendants, access to certain programs and services, and constitutionally protected rights. Justice Manson explicitly stated that this agreement should not be interpreted in an adversarial manner, but rather in light of building relationships for the future as much as it is settling long-standing grievances. In the Foster and the House decisions, which dealt with the same agreement we're dealing with today, Justice Manson went on to state at paragraph 50, which is in volume 9 of the applicant's record.
You also got it here, volume 2.
Sorry, perhaps it's easier to access the version in volume 2 of our record.
Yes.
Tab X. Paragraph 50, Your Honor, at page 596 of the record. Right towards the bottom, the sentence that starts in the last line there. The honor of the Crown rests with ensuring that the agreement, as negotiated between the Government of Canada and the Aboriginal Collective, was implemented as agreed. In the same vein, the Crown's duty to deal honorably with the Aboriginal Collective requires that the agreement be interpreted and implemented in light of its purpose and within its social and historical context. The second principle I would ask Your Honor to keep in mind while we're discussing the reasonableness of the amendments is that section 2.5 of the original agreement begins with the general rule that amendments to the original agreement can only be made when ratified in accordance with the provisions of the original agreement. And that ratification process required 50% plus one of the members of the FNI participating in the vote to vote in favor of the agreement. The subsections at issue by which the respondents purported to make the amendments are exceptions to this general rule that ratification is required. This re-ratification requirement reflects the commitment to ensuring that the terms of the original agreement have been assented to by the parties and ratified by the individuals for whose benefit the agreement was negotiated. The respondents repeatedly cite in their factum the importance of the involvement of the Aboriginal collective itself in defining their membership. The ratification criteria for both the original agreement and the re-ratification criteria for amendments is reflective of the importance of that Aboriginal collective in defining its own criteria. The third principle I would like Your Honor to keep in mind when evaluating the reasonableness of the amendments is that the respondents cite cases which stand for the proposition that principles of modern treaty interpretation should be applied to this agreement. That would mean that considerable deference is owed to the decision to amend. However, Section 2.1 of the agreement, the original agreement, explicitly states that the agreement is not a modern treaty.
Even if it's not a modern treaty, are you saying that no deference should be given to the parties who negotiated the agreement as to a decision that there is an ambiguity, or et cetera, et cetera?
We're not submitting that no deference is owed, Your Honor, but simply that the cases which deal with questions of modern treaty interpretation, which argue that considerable deference is owed, should not be applied in this case because the agreement is expressly stated not to be a treaty. Instead, the applicants submit that the agreement has to be interpreted in accordance with its stated objectives, which is the recognition of the Mi'kmaq people of Newfoundland and the fair and equitable treatment of applicants, and that it must be interpreted with the honor of the Crown in mind, as the honor of the Crown is at stake in all of the federal government's dealings with Aboriginal people.
But there is an exception in that section. It doesn't require the ratification.
That's right, there's two.
And if they meet the exception on a reasonable interpretation, then that's the end of the argument that there's a ratification requirement, correct?
That is correct. And let me tell you why.
And that provision was ratified by 90% of the people of this nation,
90% of those who voted, yes.
of those who voted.
That's correct. And let me tell you why we don't think the amendments were reasonable under Section 2.5 of the agreement.
Okay?
Let's start with subsection A. The respondents rely on both subsections A and B. So if we turn to section 2.15 sub A. That section states, this agreement may only be varied, changed, amended. We've been save and accept that the parties can agree in writing to amend without further ratification or approval. And so here's the purpose in A. To remove any conflict or inconsistency which may exist between any terms of this agreement and any provision of applicable law or regulation, so long as the parties agree that the amendments will not be prejudicial to their respective interests. The respondents allege that the conflict which would allow them to rely on subsection A stems from section 24 of the original guidelines, which provided that a signed application form was proof of self-identification.
Excuse my friend. My client is not relying on 2.15A. The only issue is the reasonableness of relying on 2.15B, and I believe that's by Mayor Friend's submission as well, acting on behalf of the Attorney General.
That's
to the general rule that ratification is required for amendments requires specifically that two criteria be met. First, the amendment must be for the purpose of curing or correcting either a clerical omission, mistake, manifest error, or ambiguity. And second, the clerical omission, mistake, manifest error, or ambiguity must arise from a defective or inconsistent provision in the agreement. The applicants submit that section 24 of the guidelines is neither defective nor is it inconsistent with section 4.1 D sub 1. Existing jurisprudence on defective contractual terms suggests that a term will be found to be defective where it is so lacking in clarity that it does not facilitate the parties' mutual understanding. In our factum, Your Honor, we've relied on the case of SBS Sealants, where the Ontario Court of Appeal held that a contractual term was not defective when the parties knew precisely what was meant by the words that were used. The text of section 24 of the guidelines is clear, and the conduct of the parties before entering into the original agreement does not indicate any lack of understanding of its meaning. The respondents specifically intended that a signed application form would constitute proof of self-identification to the extent that they did not include any other evidentiary requirements for demonstrating self-identification. It was understood that the signed application form would constitute proof of self-identification. The parties also explicitly anticipated that many applications would be submitted after the date of the recognition order. Again, the recognition order was meant to follow the conclusion of stage 1 of the enrollment process. That was the 1-year period for the enrollment process. The enrollment process lasted for 4 years in total. The respondents were aware that many applications would be submitted after the date of the recognition order. Similarly, general principles of contractual interpretation suggest that section 24, which is a general statement, an evidentiary rule of what constitutes sufficient evidence of self-identification, is not inconsistent with the requirement in section 4.1 D sub 1 that applicants have to self-identify on the date of the recognition order. Section 4.1 is an eligibility criterion. It requires that applicants self-identify as Mi'kmaq on the date of the recognition order. Section 24 is an evidentiary rule. It stipulates what kind of evidence is sufficient to establish that criterion. In the White Buffalo case, the Supreme Court of Canada emphasized that any starting point with seemingly inconsistent contractual provisions is to attempt to find a unifying meaning consistent with the party's intention. Section 4.1 of the original agreement requires that the enrollment committee assess whether an applicant self-identified on the date of the recognition order. In order to assess whether an applicant has met that criterion, the enrollment committee has the power to request additional information. They have the power to assess and weigh evidence. And they have the obligation to consider whether the applicant has established they have met the criteria on a balance of probabilities. In the case of an application form signed after the date of the recognition order, the enrollment committee could have assigned less weight to that evidence. They could have exercised their discretion to request additional evidence, and they could have come to a decision based on the entirety of the information in an applicant's file. These provisions could have been reconciled. Section 24 could have been reconciled with Section 4 of the agreement. The fact that Section 24 does not make reference to how applications signed after the date of the recognition order will be assessed does not rise to the level of being manifestly inconsistent or repugnant to the rest of the agreement. Indeed, nothing in the original agreement evidences any intention that the parties intended for all applicants to provide objective documentary evidence of self-identification. To the contrary. Second, even if Section 24 was a defective provision or was inconsistent with the self-identification criterion, which is not admitted but denied, the addition of the objective documentary evidence requirement far exceeds the scope of the amendments contemplated by Section 2.5 of the original agreement. The amendments go well beyond curing any alleged defect or inconsistency as intended by the exceptions to the general rule that substantive amendments would require ratification. These amendments go to the core of the original aspects of the original agreement, which, as the evidence demonstrates, resulted in a significant variance between the percentage of applications approved based under the original agreement and those evaluated under the amended criteria. Furthermore, to the extent that the amendments purport to ensure that applicants self-identified on the date of the recognition order, the amendments overcorrect by requiring that the objective documentary evidence predate the signing of the agreement in June of 2008. We have to keep in mind, Your Honor, that the amendments do not require that applicants provide objective documentary evidence that they self-identified on the date of the recognition order. They require that applicants who signed after September 22nd, 2011 provide evidence of self-identification from June 2008 or earlier. If the objective of the parties was to cure a defective or inconsistent provision in Section 24 as it relates to the criteria that self-identification must have occurred before the date of the recognition order, there are a number of ways in which that defect could have been cured, which would not have required only a small group of applicants to produce evidence from 3 years earlier than other applicants. For example, individuals who applied after the date of the recognition order could have executed a revised statement attesting to their self-identification on the required date. This requirement would have been most akin to the requirement that those applicants are subject to who signed their application forms on September 22nd or before. Additionally, the applicants have not suggested that Section 4.3.3 of the original agreement, which outlined the appeal rights of the applicants, was in any way defective or inconsistent with another provision of the agreement. And yet they amended that as well.
Going back to your earlier point, not dealing with the appeal rights, but the submission you've made that, that the responding parties could have done things differently if they, in fact, were of the view that there was an ambiguity, et cetera, et cetera. I mean, how much, if at all, should the court be involved in looking at that issue? I mean, if there is an ambiguity, if I find there is an ambiguity, then unless there's some evidence, I would suggest that, bad faith or ulterior motive or something, isn't it up to the parties to decide how they want to correct it? Because I agree with you, there's any number of different ways that, on the face of it, and it may well be that the parties considered some of them, I don't know. But isn't that a matter left to the parties as opposed to the court to intervene and say, well, you could have been less invasive in terms of the amendment, you could have done it differently and therefore it should be set aside? I mean, that strikes me as being something beyond what the court should be doing, frankly.
Of course, Your Honor. And the role of the court today is to determine whether the amendments that were made were reasonable. And in Dunsmuir, the Supreme Court of Canada stated that an evaluation of the reasonableness of a decision has to examine both the reasons for the decision and the outcome. Those are both relevant to the question of whether the decision at issue was reasonable. If we take the stated objectives of the respondents for these amendments, ensuring that all applicants be treated fairly and equitably, if we keep in mind the reason for the original agreement to begin with, the recognition of the Mi'kmaq people of Newfoundland, restoring status to the descendants of those people who should have been recognized in 1949. We have to keep those purposes in mind when we look at the amendments that were made. Were the amendments, were they reasonable? Is requiring an applicant who signed an application form one day after another applicant, is requiring that applicant to provide evidence from 3 years before, does that achieve the objectives that the respondents have stated was the whole goal of the original agreement and the supplemental agreement? That's on the reason side from the Dunsmuir ruling. You also have to look at the outcome. What was the outcome of these amendments? We've been over the numbers. The outcome was a huge disparity in the percentage of applicants who succeeded if they signed their application on September 21st or September 22nd or before, versus if they signed on September 23rd or later. Both of those aspects of the decision are relevant to your evaluation.
I mean, I understand, I appreciate your submission with respect to the percentage, but and it's true that as I understand it, that the committee did reject them on the basis of self-identification, but I don't know that I have any proof that that they would have passed on all the other criteria that had to be met.
Right, but we're talking just about the percentages for self-identification.
Well, I know, but that was, put it in very vernacular, an easy out for the committee. You haven't done it, we don't need to look at all the other things. Whereas if the rule that had been in place before continued in place, then the committee would have had to turn its attention to the others, which are not necessarily as easy a determination as saying, look, you haven't provided the paperwork that's required and therefore you're out. Now, I'm just not sure that the 90 some odd or whatever it is percent really, I'm not sure that it proves the point that you're trying to say, because the committee, I don't have any evidence that they would not have been rejected in any event. I don't think.
And no one necessarily knows the answer to that question. But the fact that 100% of those who applied on September 22nd or earlier passed the self-identification test, and
it was a pretty easy test.
Fair enough.
I would have been shocked if somebody hadn't passed it.
Well, I question how one could have not passed it if they had signed their application before September 22nd, 2005. It's my understanding, I'm sure my friends will correct me if I'm wrong, because they're more involved, and Mr. May particularly was involved in this whole process, but it was my understanding that the enrollment committee evaluated ancestry first, then self-identification, then group acceptance. So the people who have been rejected on self-identification had at least met the ancestry hurdle, from what I understand, were rejected on self-identification, and what was left to be determined was group acceptance.
You may be right, but I'm not sure that's in the record. I don't remember reading that anywhere. But if it's there, somebody tell me.
I hope I've answered your question in any regard. And I would like to move on to our second argument that unless...
Let's take our morning break then. We'll take 15 minutes. Thank you.
And we're taking the morning break in courtroom 5D at Federal Court of Canada, 180 Queen Street West in downtown Toronto. The case of Wells versus AGC and the Federation of Newfoundland Indians, the Mi'kmaq First Nations Assembly of the Newfoundland case. We're going to break for 15 minutes. The sound here in the courtroom is quite low, and I will speak to the court staff about perhaps turning up the volume, but some viewers have indicated that using headphones makes things a bit easier. So we'll pause for about 15 minutes. I'll be back soon.